My name is Susan Daicoff. I'm a professor of law at Florida Coastal School of Law. Been there since, came the first time in '98. Then I left for a year, and then I came back in 2000. I've been there ever since. But you want a little bit of my background. So I went to the University of Florida for undergrad. I started college when I was 14 and graduated when I was 17. And so I'm still, I think, the youngest admit ever to the University of Florida College of Law. And I was on law review and got order of the coif at the University of Florida. I finished there in about '83, and we were talking about book awards. I booked Corporate Finance and Evidence, I think, from what I remember. And then I went on to NYU for an LLM in tax, and finished that in '85. And I was on the tax law review at NYU, which is a scholarship. So I was a Wallace Scholar, basically. Then I got a master's degree in clinical psychology, a terminal master's from the University of Central Florida after I practiced law for a while. But after I left NYU, I went with a smaller firm in Orlando, but we were general corporate counsel to a really large publicly held company. And so in the mid to late 80s, I did merger and acquisition work until the stock market crash of 1988. And had every bit of a high level corporate practice, corporate securities and tax practice that you could ever want. And that was pretty much what I was promised, and that's exactly what I got. So I really enjoyed that. Then I went back to school at the University of Central Florida in Orlando for clinical psychology and finished that, and did a couple of years of working in that field as an intern in psychotherapy. And then I went back to the practice of law in a small boutique tax firm in Tampa before I became a law professor in 1995. And my first professor job was at Capital University in Columbus, Ohio. And I did that for about 4 years before I came to Florida Coastal. So I've been a professor for the last 13 years and a lawyer for 24 years. I also wrote, before I became a professor, I wrote a couple of chapters for the tax practice series for the Bureau of National Affairs, the BNA tax practice series, which is one of the practice materials that I used quite a bit when I was a tax lawyer. But that helped when I became a professor. And wrote my master's thesis at the University of Central Florida in '92. I wrote that on the ethical decision making by lawyers. One of the things I found in the research about lawyer personality is that not only do lawyers, and this is a generalization, and I know we're making broad, sweeping generalizations, and so you have to kind of take them with a grain of salt, because many people are going to say, well, I don't fit that mold. But many lawyers make decisions, moral and ethical decisions, on the basis of logic, rationality, rules, regulations, logical analysis, and they don't necessarily take into account human relationships involved in the question, or emotions. It's not to say that lawyers are not emotional. We're not saying that lawyers don't have feelings, or that they don't take those into account. But when making decisions, what they base their decisions on is not usually how people are going to feel about what they're going to do, or how that's going to affect the relationships involved in the particular situation. So there was some commentary that that might be a problem, that might explain some of the distress and dissatisfaction in the legal profession, that maybe lawyers as a whole, and maybe that should explain why some clients perhaps did not particularly appreciate the legal representation they'd received, or were not particularly satisfied with their lawyers. So I was interested in that, because there was some data to show that, at least on the Myers-Briggs type indicator, which is a personality test, and it's not a clinical psychology test, so we can take it also with a grain of salt. But there's a lot of data about lawyers in the Myers-Briggs, that very few lawyers, about 20%, operated from a feeling perspective on decision-making preferences, and whereas about 78 to 80% of lawyers operated that way. And the general population is much more evenly split. It's about half and half. And men are more thinkers, and women are more feelers. in the general population, but the lawyers, both male and female, were overwhelmingly thinkers. So that makes a lot of sense, but it also suggested to me that there was a communications gap between lawyers and their clients because of the different thinking styles and the different decision-making styles that they used typically, and that perhaps spoke different languages, and that perhaps lawyers didn't take into account the same kinds of values or place the same importance on factors such as relationships and emotions and that sort of thing, and mercy, that maybe some of their clients did or the general population did. And that might explain why the general population didn't particularly like lawyers. So then I thought, well, is that trait adaptive? Should we keep that trait? Or is it possible that some of that has something to do with these inordinate levels of lawyer distress and dissatisfaction? Maybe not inordinate dissatisfaction, but you certainly see inordinate levels of lawyer distress, including depression, anxiety, alcoholism, that sort of thing in the legal profession. So through exploring that and exploring whether approaches to the law that were more attuned to emotions, to relationships, to maybe things outside of straight legal, rational, logical analysis might be useful, might be positive. I started to begin to look at therapeutic jurisprudence, and then I went to a conference in early 1998, I think in Redondo Beach, a therapeutic jurisprudence conference, at which Professors Wexler and Winnick had invited folks from the collaborative law area and from restorative justice to look at these two emerging disciplines as potentially therapeutic jurisprudential type ideas. And I said to myself, there's two things here. Number one, this is a movement, that therapeutic jurisprudence, collaborative law, and restorative justice are three vectors of a movement. And vectors is not my term, it's a term that Thomas Sheff wrote about in terms of therapeutic jurisprudence and restorative justice. He published this wonderful article where he said there's a movement and there's two vectors, therapeutic jurisprudence and restorative justice. And I said there's more than that. There's all these other vectors. So what I realized in that time was that there were a lot of different people in different disciplines all throughout the legal profession that were all thinking similarly in different discrete places. But they all had a similar sort of mindset about how the law could be improved. And the second thing I thought is that this may be exactly what the legal profession might be lacking. That some of the values and some of the things that are important in these emerging disciplines, in therapeutic jurisprudence, collaborative law, and restorative justice at the time, those are the only ones I knew about, are some of the values and the factors that are de-emphasized in law school, that are de-emphasized in the practice of law, and that are de-emphasized in these personality traits that I've been studying among lawyers, and yet we have these inordinate levels of distress. So I'm wondering if there isn't a link here, and also knowing that some of these emerging disciplines were born out of some lawyers' dissatisfaction with the current system. So when I put it all together and I said, all right, so clients aren't particularly happy with their lawyers. Society as a whole isn't particularly happy with lawyers or the legal system. Lawyers themselves are not particularly healthy as a population. If you look at, most of the lawyers are healthy, but then you have this nice big chunk, 20%, twice of what you would expect, are suffering from depression, alcoholism, something like that. That's too many people in a profession to suffer like that. So something needs to be fixed. And here's a bunch of people that are developing new ways of practicing and adjudicating law that are more humanistic and more humane and supposed to have a better and more positive outcome. Might these be related? Might this all be a part of a bigger picture? And so that's why when I wrote Lawyer Know Thyself, I put comprehensive law practice or comprehensive law movement at the tail end of that book. Because to me, it sort of heralded the way of, here's all the problems, here's what seems to be going on based on the data in the legal profession. Here's one possible option for a way that we might change or innovate in the legal profession, and it might solve some of the problems that the clients and society are bringing to us, and that some of our distressed lawyers are bringing to us, possibly.